Ladies and gentlemen, good afternoon. My name is Emily Miao, and I am a partner at the law firm of McDonald, Bain, Holbert, and Berghoff, one of the sponsors for today's event. I'm so excited to be here today and to have the opportunity to introduce our keynote speaker, the Honorable Margaret McKeown of the United States Courts of Appeals for the Ninth Circuit. Judge McKeown was appointed as a Ninth Circuit judge by President Clinton and was confirmed by the United States Senate in 1998. She attended the University of Madrid and graduated Phi Beta Kappa from the University of Wyoming with a BA in 1972 and from Georgetown University Law Center with a JD in 1975. She received an honorary doctorate from Georgetown University in 2005. Judge McKeown was a White House Fellow in 1980 to 1981, serving as a special assistant to the Secretary of the Interior and special assistant at the White House. In 1993, she served as the Japan Society Leadership Fellow. Judge McKeown is an immediate past president of the Federal Judges Association and chair of the ABA Rule of Law Initiative Board. She served on the Council of the American Law Institute, the Executive Council for the American Society of International Law, the Managerial Board of the International Association of Women Judges, and the Editorial Board of Litigation Journal. She is the Vice Chair of the Georgetown Law Board of Visitors and Jurist in Residence at the University of San Diego Law School. She is also an advisor on the ALI restatement of the law in copyright. Judge McKeown has lectured and taught extensively on intellectual property, international law, litigation, ethics, judicial administration, and constitutional law in Latin America, Asia, and in Europe. She has also authored and co-authored numerous papers and a book, which are listed in your materials. Judge McKeown had received a number of prestigious awards, including the ABA Margaret Brent Women of Achievement Award, the Georgetown University John Carroll Award, the Georgetown University Law Center Outstanding Alumni, the University of Wyoming A&S Outstanding Alumna, the Outstanding Mentor Award from Big Sisters, the Federal Bar Association Community Service Award. She also received the Girl Scouts Cool Woman Award in recognition for her personal and professional achievements, which essentially makes her the consummate role model for women, for girls, excuse me. Judge McKeown has been active in community and civic affairs. She has served on the National Board of Volunteers of America and the Girl Scouts of the USA, and she is the past chair of the White House Fellows Foundation. On a final note, she is truly a cool woman, and we are grateful for her presence with us today. Without further ado, please join me in welcoming Judge McKeown, who will be delivering the keynote address entitled Censorship in the Guise of Authorship, Harmonizing Copyright and the First Amendment.
Thank you, Ms. Miao, for a lovely introduction, and thanks to Professor Lee and to the law school for inviting me today. I bring what I like to say are greetings from the digital circuit. The Ninth Circuit Court of Appeals, with which many of you may or may not be familiar, spans from San Diego, which is the heart of the wireless industry, to Silicon Valley, to Market Street up in San Francisco, where we have Uber and Twitter just down the street from our courthouse. We have the Portland Tech Corridor, of course, with Intel, and we have Seattle's tech-rich environment, Microsoft, Amazon, and many others, and Starbucks, which is not so tech. Some say that we're the Hollywood circuit. Other people say we're the left coast circuit. And it's hard to believe, but I have even heard us called the most reversed circuit by the Supreme Court. So let me, since we're in classroom mode, take a little survey. Has anyone else heard that we're the most reversed circuit? Come on, fess up, you can raise your hand. Of course you've heard that. And it's important to talk about it today because we're here for the Supreme Court review. Now you might think I might be a little sensitive being from the Ninth Circuit about this topic, but I'm not. Take last term. We had a 63% reversal rate. 9 circuits were higher. I said, well, maybe that's an aberration. Let's go back a decade. 83% reversal rate, 7 circuits higher. So there are a number of circuits consistently that have a higher rate of reversal than the Ninth Circuit, and there's no doubt that we've had our years of high reversal rates. But to be sure, that myth about being the most reversed circuit is exactly that, a myth. So while I'm going to talk with you about copyright and First Amendment, that's the first takeaway I'd like you to take home. I am not going to give you some cataclysmic proposal today, as came from my good friend and colleague Diane Wood when she spoke here a few years ago and said that we should take back in the circuit courts all the patent cases. Instead, I want to focus your attention on something and an issue that is prominent in our circuit dockets, and that is copyright in the First Amendment. We actually enjoy and cherish our copyright, trademark, and other intellectual property cases. And unlike in some foreign judiciaries, I don't really see those as going to a specialized judiciary. So I think it's almost a cliche to say that the copyright and the First Amendment are both in tension and synergy. No doubt that observation is broadly true, but I think we've muddled the specific implications. I suggest to you that the most oft-discussed tension in this area is sometimes dubbed crowding out. And I think that that is overblown in terms of what we should be talking about. The tension that I want to talk about is the growing number of claims that invoke copyright protection to remedy what I call personal harms, such as invasion of privacy. And in the process, they trump on the First Amendment. In simple terms, a trumped-up copyright claim cannot justify censorship in the guise of authorship. So what I plan to do this afternoon is to sketch briefly this background and then turn to a case, Garcia v. Google, that highlights this tension. I want to touch on several other examples that are percolating now through the federal courts and suggest to you why is it that copyright has become a go-to remedy in this area. And finally, we'll come back to First Amendment and copyright basics. Now, everybody here is familiar with the long-standing rationale of copyright: the incentivization, the creation of new expression by guaranteeing that limited monopoly. By definition, copyright does put some boundaries on speech. In fact, the Supreme Court has said that copyright itself can be an engine of free expression. But when we think about free speech, to be honest, we traditionally think about the First Amendment, not about copyright. So let me go back to that issue of crowding out. In the face of these potentially competing values, a number of scholars have argued that there's this inherent conflict. Professor McKeown from University of San Diego Law School doesn't subscribe to that theory, but he had a pretty good definition of it that you see here. And that is, as you see on the chart, year after year through various legislation, Congress has upped the copyright protection or the scope of copyright protection by increasing the limits. The argument goes that this expansion, in effect, constrains diversity of speech and hampers a robust public domain. Now, ever since Professor Nimmer identified what he called definitional balancing between these two concepts, advocates have tried to have some kind of balancing of competing values. I suggest to you the reality in the courts, though, is something quite a bit different. There was a Southern California Law Review article a few years back that looked at 30 published cases over a 35-year period. And in all but 2 of those cases, courts had rejected this conflict thesis, the crowding out thesis. So in my view, with few exceptions, the ship has kind of sailed on that argument. Maybe the biggest case in point is when the Supreme Court was asked, somewhat metaphorically, please free Mickey Mouse, and invalidate a dramatic extension of the copyright law. That's a case that you recognize as Eldred v. Ashcroft. But there, the court rejected that claim and said that copyright's limited monopolies are compatible with free speech principles. And what the court is also going on to say, as long as you stick within the broad contours of what copyright was intended for, then you don't have a First Amendment problem. Now, the court returned to that theme just under a decade later in the case of Golan v. Holder, and once again said that extending copyright protection, in this case to works that were previously in the public domain, didn't violate the First Amendment. And important to our discussion today, the court called out two things that are in the copyright regime that it talked about as built-in First Amendment accommodations: idea-expression dichotomy and fair use. Now, the idea-expression dichotomy, of course, is intended to insulate ideas from copyright coverage, but instead to give statutory protection only if you have an expression or a representation of ideas. So the idea is that this division that the Supreme Court talked about gets to the core concern of First Amendment values, and that is ideas are up and open for a free discourse. Now, you could argue where the courts have drawn the line in this dichotomy. And years back, Judge Hand said, nobody's ever been able to figure out where the boundary is, and nobody can. Well, the fact is we have to. So maybe we can't, but we do, and we must. So in fact, that's what courts struggle to do, is figure out where is that dichotomy. Turn then to the other side of the coin, fair use. And it likewise promotes free speech and new expression. The fair use doctrine, of course, permits use of copyrighted materials for limited and transformative uses. And we'll get back later, well, what does that mean? So many of these things are easy to write up in a statute, easy to give a name to, and they're not so easy necessarily to apply when you actually have to do it. But I think this defense, way more than the idea expression, really defies how you apply it and where you draw the line. I might describe it even as a lawyer's mini relief act, because there's millions of dollars are spent every year trying to figure out, is it fair use? Is it not fair use? The Supreme Court has identified this as an accommodation to the First Amendment. Courts and others haven't been quite as charitable. One court said it's the most troublesome doctrine in copyright. A few academics have been less charitable, in fact. They've said, this is billowing white goo, this fair use idea. And another academic said, well, it's not but a fairy tale. So I'll let you judge for yourself on that. So it's probably not surprising in the face of this debate about crowding out and then fair use and the idea-expression dichotomy that I'd like you to hear from Professor Christopher Eisgruber. He's an outsider to copyright law, but he's an insider to constitutional and to free speech jurisprudence. So he says there really is something very puzzling about this tension that is called out about crowding out. And what he basically says is, clearly, traditionally, copyright and free speech are consistent with each other. Copyright doesn't censor in the way you think about speech being impinged on. Copyright doesn't pick and choose against whether I like it or don't like it, whether it's smutty or subversive or whatever. Now, the professor's view, I think, is probably true in an absolute sense. And his observation does help us understand why cases like Eldred and Golan just didn't go anywhere. But in my view, there's a very different and another story to tell. And that's what I call copyright as censorship, which does exist, and it is different from this crowding out idea. The manifestation of this tension is when you use copyright to put prior restraints on offensive, unpopular, or sensitive speech. So let me go back and take a page from those early days of software copyright and tell you that these cases that are using copyright to be a prior restraint, in my view, they look, feel, and smell like First Amendment cases, more than copyright cases. And what they're fundamentally about is the censorship of unpopular speech. I've talked about the broad perspectives. I'm focusing you now on this notion that we're really talking about the tension between copyright and censorship. So now let's talk practicalities, and I'll give you a real live example. I turned to Garcia v. Google as an illustrative case decided by the Ninth Circuit in Bank Court last spring. And of course, I have to make a disclaimer. I did happen to be the author of this opinion. So I tell you that in advance, and you're welcome to disagree with me later or to agree with the dissent. Here's the factual backdrop. A young woman named Christy Garcia got paid $500 for a bit part, and she thought she was going to be in an adventure film. She had 2 lines and 5 seconds of screen time. Now, there is no doubt that Ms. Garcia got bamboozled by the filmmaker. He claimed he was going to make an action-adventure thriller set in ancient Arabia. Well, what happened actually is he dubbed over the few lines she had, and he turned the film into an anti-Islam movie. The title of the film was to be Innocence of Muslims, and it was intended as a movie disrespecting the Prophet Muhammad. Now, when a 14-minute trailer of it got translated into Arabic and then uploaded onto YouTube in September of 2012, there was an outrage and violent protests across the Middle East. The video has even been linked to the Benghazi attack, although that's hotly disputed. So now I'm going to play an excerpt for you, available on YouTube, and I've chosen not to include in this the little portion in which Ms. Garcia had her part. Hopefully can bring this up. Here we go. So here now they're burning up a pharmacy and a home of some Christian adherents.
Mohammed is the back. Your lady, something. My lady? My lady? Oh, don't finish, Junior. Oh. I'm watching you. Don't finish it. Go up. Honest, I know you are glut. Honest.
Okay, you bastard, the unknown father.
What did you say?
Okay, the unknown father.
Take me back. Hey. Not enough to believe in one doctor. Must say God and Muhammad is the messenger. Now, go.
Well, I won't bother you with any more, but you don't have to be a film critic to see that this was not a candidate for the Oscar. The film was called Amateurish and Offensive, and it went on and on and on with very similar scenes. And you can judge for yourselves that it was somewhat of a ham-handed attack on Islam. But the question is, should it have been banned under the copyright laws? So Ms. Garcia decided to file suit first in California state court under various tort theories: defamation, hate speech, publicity, privacy. And she got nowhere. The state court refused to issue a takedown order of the film and said she was not likely to succeed on the merits. She sued both the filmmaker and Google, owner of YouTube. 5 months after the film had been up on YouTube, she then turned to the federal court, and she asked the court to order removal of the film once again. The district court said, no, I'm not going to do that. You really have a weak copyright claim, if at all, and I don't see irreparable harm in the copyright sense. Well, the Ninth Circuit, in a 3-judge panel, reversed. Judge Kaczynski, joined by one other judge, concluded that she did have a fairly debatable copyright claim in her 5-second performance, and that the threat against her, because there was a fatwa issued against everyone associated with the film, was irreparable harm. There was a dissent. So the panel first issued a takedown order, saying that Google had to take all the copies of Innocence of Muslim within 24 hours and couldn't disclose the existence of the order till there were full opinion. It then revised the order and said, okay, you can show the film, but you have to take down and edit out the part featuring Ms. Garcia's performance. So despite the court's role as a film editor, the result was no surprise. The entire film just remained off the internet for a long time. The Ninth Circuit voted to rehear the case in bank, and we affirmed the district court. In other words, we dissolved the injunction against the film. It was a 10-1 decision, and Judge Kaczynski, writing as the only person in the dissent, reiterated his view that he had put forth with the panel. Now, the central reason that we wrote in the en-banc court is that Garcia wasn't likely to succeed in her copyright claim, and she had shown no copyright harm. So there's 3 important takeaways I want to talk with you about from the legal analysis here. Number 1, hand-waving does not make a copyright. 2, the copyright remedy has to fit copyright principles. And 3, a weak copyright claim can't trump the First Amendment. So let's go to the first of those points. Copyright protection, as you know, rests on a very precise statutory scheme. You can't just wave your hands and say, it seems like she should have protection, it seems like she should have a copyright, and therefore it should be. Now, it harkened back in my mind to my son when he was in grade school. He'd been to one too many of seminars like this where I had to put him in the back of the room with a coloring book. And so he made some artwork for Father's Day, and on the back of it put a copyright notice. And the teacher said, what is that? And it was actually, I think, even before we had signed up to the Berne Convention where you didn't need a copyright notice. He said, well, it's a copyright. I'm the author of this work. And the teacher said, I don't even know what you're talking about. So, but the point is, you do have very precise statutory requirements you have to comply with. So to begin, this 5-second performance that's within an entire film is not a work, separate and apart from the film. And as I wrote, you can't just kind of cherry pick bits and pieces from a unitary work and then basically say you have a copyright in this, 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 and this. Because that would turn what I think is a unified copyright scheme into one that you can only call Swiss cheese. And the practical result, take a movie, for example, is that you would fragment a movie into thousands of copyrights. Think of the fight scenes in Lord of the Rings or the crowds in Ben-Hur. Now, it's interesting because although the Copyright Act has lots of definitions, it doesn't define works of authorship. How strange is that? But it was clear that Ms. Garcia wasn't the author here. She didn't author anything. And she certainly didn't fix her performance into a film, and she certainly didn't authorize the filmmaker to change her performance. She didn't authorize anything. Now, normally you're thinking to yourself, oh, wasn't there some kind of an agreement, a work for hire, or something that would solve all this? Well, there usually is, and there often is in Hollywood, but not always. Here, that was disputed, and it wasn't an issue on appeal. So that's the first takeaway. You really have to look, if you're going to have a copyright claim, you have to look at what the definition is and whether you really have something that's copyrightable. Now, second, when you talk about harm under the copyright law, you need irreparable harm in the copyright sense. Here, there's really kind of a fundamental mismatch between copyright and the irreparable harm that she was claiming. She was claiming invasion of privacy, death threats. And of course, the purpose of copyright law is creative expression, not to protect secrecy. So if I use criminal law lingo, I would say the punishment didn't fit the crime. Now you might think, whoa, my gosh, does that embanked panel have no heart? And I would say we had a huge heart. We were wholly sympathetic to her plight. But the question is, was copyright the way to get there? So in the end, we said, although we don't take lightly the threats and certainly the emotional turmoil that she, and actually lots of others associated with the film against whom this fatwa had been put out, we don't take that lightly, but her claims are untethered from what copyright's function is as an engine of expression. Now, we're all familiar with the fact that under American law, we don't recognize reputational harm, moral rights, the right to be forgotten, which was, of course, recently validated by the European Court of Justice. So maybe she would have had a better case in Europe. And indeed, I suggest to you her privacy interests might have been treated differently. But at the end of the day, there was a fundamental mismatch here. Which brings me then to my third point, and that is the First Amendment. You can't take either a non-existent or a weak copyright claim and then try to hijack the First Amendment to suppress unpopular speech. The initial order to take the film down from YouTube, that was basically a mandatory injunction and a prior restraint of speech. And we all know from first-year constitutional law that those are high legal hurdles, very much disfavored in constitutional law, and they put a very, very high burden on the person making that argument. So here we said, of course, what that injunction had done basically was it suppressed a politically significant film based on this dubious and truly unprecedented theory of copyright. And in doing so, you basically deprive the public of the right to see the film and judge for themselves. Now, Judge Reinhart, who is not on the panel, also filed a separate opinion stating that he agreed with the majority, but is in his view, the Ninth Circuit should have immediately gone in and had this embanked hearing in order to avoid the continuing irreparable harm to First Amendment rights. In other words, the circuit should not have taken the normal embanked process. It should have stepped in on an emergency basis. So that case, I think, illustrates for you this tension that I think is much more real than the crowding out. And that's this tension between when copyright comes in and when the First Amendment comes in the case of trying to suppress something that's unpopular. Now, Garcia's case is not a one-off, and it doesn't stand alone. It's really one of many where plaintiffs invoke copyright to try to halt personal attacks. We've all been reading the papers of late, and we see there's a lot of high-profile data breaches and email hacks that have prompted victims to look to copyright for protection of their image and reputation. Ashley Madison, Hulk Hogan, Sony, all of these hack situations cause someone to say, what about my privacy? What about my copyright interests? So it's no surprise that facts matter. I'm going to give you two cases, Exhibit A and Exhibit B, and together they invoke the very same principles as Garcia, but with two very different outcomes. It's no surprise because, as we know, even in the Court of Appeals, facts do matter. So here we go. I call it the cottage industry of the copyright and the First Amendment. You might recognize Hulk Hogan there. He's got a high-profile legal fight with Gawker, which of course is a news and gossip website. Gawker found a sex tape of Hogan having an affair with a mistress, and they posted it onto the internet. He first pursued a preliminary injunction in federal court. What was the theory? You guessed it. It was a copyright theory. He said, I own those photos. This wasn't necessarily one of the photos that was a little more distressing to him. But he said, I own it. And the judge down in Florida said, whoa, wait a second. All you really want to do is perfect your professional image, and you want to stop a personal harm because you think this is a private question. But that isn't irreparable harm in the copyright context. So the result so far mirrors Garcia v. Google. He then moved to state court, and he said invasion of privacy, and he got an injunction. Now he enjoyed better success, and I think the case is set to go to trial in a year. Now we'll go to Exhibit B. This next case highlights two of Garcia's principles. One, the importance of the statutory provisions of copyright, and in this case, fair use, and that intersection of copyright and the First Amendment. So here's the story. There's two music pop stars. They sued this magazine called TV Notice for copyright infringement. The magazine printed photos of their secret Las Vegas marriage. Now, they hadn't even told their parents that they got married. And in fact, the husband was the producer and the wife was the singer, the pop singer. And they thought it might actually change the market for her music and her popularity if they disclosed that they were married. So they went to Las Vegas, home of what goes on there, stays there, and got secretly married. Kind of was like, as I say, it's like a little telenovela or something. But always beware of your disgruntled bodyguard or driver. He found a little pen drive in one of the cars, and on the pen drive were all kind of photos. Some of them a little less marriage-looking than those. And he took those and he sold them basically to TV Notice. And he said, I should be able to do this. And the magazine said, hey, these are really newsworthy because of this couple. And the publication was fair use. In the end, the Ninth Circuit, and again, I'll make a fair disclosure, I wrote the opinion, said that this was commercial publication, and looking at all the fair use issues, it was not transformative, and they did not show fair use. So the magazine could not publish them. It would have to go back to the trial court and work out whether there was a real copyright, what were the claims. Ultimately, apparently, that case settled. But it's not an easy case, because the magazine said, hey, this is newsworthy, and that trumps any claimed copyright. And of course, just as the Supreme Court said when it addressed President Ford's memoirs in the Harper v. Roe case, every commercial use is presumptively an unfair exploitation. So playing off of that phrase, I wrote that fair use is not an automatic get-out-of-jail-free card just because you're a news organization. Now, I recognize that the First Amendment dilemma is inherent every time you go through these fair use questions. But this whole notion of transformation is also somewhat elusive. So our charge, of course, is to look at the case overall, not just the headlines. And we can't sidestep that very clear copyright law that says you have to look at the purpose and character of the film, or in this case, the pictures, the nature of the work, the amount taken, and what's the effect on the potential market. So in a case like this, I think you can legitimately question, does fair use provide enough of a First Amendment release valve for these First Amendment values? Now, my colleague in dissent said, no, this was censorial, and basically now any celebrities could waltz in and say, I invoke copyright protection, therefore don't disclose anything embarrassing about me. That, of course, in my view, overstates the proposition because, of course, you have to look at each of the fair use values, put them in some kind of judicial blender, and of course come out with a resolution. But the two cases do illustrate two, but a steady stream of cases in federal courts where one side invokes copyright for personal protection and the other says no, copyright is tantamount to censorship. Now there's a couple more examples I can give you, and I'll just briefly run through just to give you kind of a flavor of these. Hustler, publication you've at least heard of, maybe you've even read it. They had a wet t-shirt contest and they published these photos of a woman who then sued for copyright. That case actually went to a jury, and the jury rejected Hustler's fair use defense. Another case just came out of the 11th Circuit last week, involved a Miami businessman and a partial owner of Miami Heat. Apparently there was a blogger who was dogging him, and his mission was to criticize this businessman, and he published some photos taken in Israel that were ostensibly very unflattering and not particularly helpful to the businessman. Just last week, the 11th Circuit actually sided with the blogger, and they said that the lawsuit was an attempt to utilize copyright as an instrument of censorship against unwanted criticism. Another case, which I want to share with you because I really find it kind of amusing what Professor Rebecca Tushnet wrote about it. She says, if hard cases make bad law, it may be that sometimes jerks make good law. And so here's the case she was talking about. There's a student at Liberty University posted videos about the former dean. The dean supposedly filed a bunch of takedown notices and said, get rid of those, that's unfair, they're dishonest. He had previously claimed that he'd been raised as a jihadi Muslim, and then somewhere along the way, he was able to convert to evangelical Christianity, and it turned out none of this was true. So, in the end, he lost his position at Liberty. The student won the lawsuit, and of course, the dean lost his copyright claim in court. And finally, one last example, there's a case still pending, but there's been at least a final judgment. A California city sued one of its citizens, saying that the citizen couldn't use the public tapes of the city council proceedings to criticize the city. So one more example, a city this time invoking copyright to say, don't say bad things about me. Now, when you put things onto the public domain, as you know, you have a lot less control. And I'll give you just one very short vignette. I had a national security case in which we permit filming in the Ninth Circuit, one of the very few circuits that do permit it. We get calls from C-SPAN and others. It's usually on at midnight. You know, your relatives call and say, I was sleepless and I saw you on TV at 2 a.m. or something like that. Well, in that particular case, the first I heard was a law clerk from New York called me and said, I saw you in a movie. I said, a movie? I've never been in a movie. They said, oh yes, Citizen 4. You're featured prominently at the beginning of the movie along with your panel members. They had taken the public footage. We'd never been consulted. I now have my own IMDb listing. And I was in an Oscar-winning film, unwittingly, I might add. So one of the things you might say to yourself is, well, why are people using copyright as a go-to tool? Well, I'll just hit a couple of reasons. One of these is I think the internet has been a game changer. This is a very funny cartoon that says the internet is like nature and it basically wants to kill you. I licensed this cartoon from a wonderful cartoonist who corresponded with me, and he said, yeah, you can use it, but I want a picture of you using my cartoon, so that's why we've stopped for her to take that. So you can imagine I'm a little bit sensitive in these presentations about copyright. But to say that the internet is ubiquitous is really to understate its reach. There's 3 billion people on the internet, and how many of you are on Facebook? You know, most everybody. Well, okay, join your 900 million friends on Facebook. But what you have then is the potential for huge amounts of infringement, but huge amounts of creativity. And the internet, of course, knows no borders, so in many respects, the lid is off. All these traditional principles of territorial jurisdiction, national privacy laws, and the like have gone by the wayside. Why else are you seeing the internet? And why else are you seeing copyright as a go-to tool? Well, one is the Digital Millennium Copyright Act, and I have a little dyslexia often with this. I often write it out as the DCMA, which of course relates to government contracts and not to copyright. But it's a very potent statute. It gives internet content providers a safe harbor if they remove content after receiving a takedown notice. Now, it doesn't always happen in Google v. Garcia. They had, of course, declined to take down. And a case just came out of my court last week, which is called the Dancing Baby case, in which a mother put up her kid to dance around to Prince's, Let's Go Crazy, and got a few takedown notices. And the court said, well, you know what? You do have to look at fair use before you send those out. But that's a potent tool. The copyright is a potent tool. You get automatic federal question jurisdiction, free pass into federal court that you might not get. It's essentially strict liability, and of course very strong statutory damages, can go up to $150,000 per violation if it's willful. So again, a very powerful. We already talked about the pitfalls of fair use defense, so you don't know if you're going to have a safe harbor there, thereby prompting some people to say, might as well pay my money, take my chances, and see if I can get my copyright claim extended. Another reason, the crushing weight of injunctions. Almost all these cases, particularly involving speech, are resolved at the injunction stage. Why? Because it's an up or out proposition. But if the injunction is wrongly issued, before there's a full exploration of the facts and a full determination of what the rights are, protected speech may well be stomped on. So it's an effective go-to remedy, even in the post-eBay world where you no longer have a presumption. Another reason I suggest to you is that we have in the United States kind of an imperfect and porous privacy regime. We don't have a big, highly structured national privacy law. Of course, we have various constitutional amendments, and we have select privacy laws with various subjects, and there are many, many of them. And a number of state constitutions kick in, even better. But we really don't have an integrated scheme like they do in some other countries. So again, copyright injunctions have become as a proxy for privacy protection. The last reason I'd say is cultural shifts might also matter, because to some degree, there may be a cultural shift in attitudes not only about free expression, but also about how we think about copyright. This is a quote from a fairly provocative guy who once wrote for a libertarian Marxist publication, but he's basically saying that in the West, we're dancing on eggshells, and we're always saying but when we hear questions about whether to stop speech. Now, he gives as examples the Salman Rushdie and also the aftermath of the Charlie Hebdo disaster. So whether you agree or not, the point is we don't have cultural homogeneity about the contours of free speech. Another trend is that we also are not homogeneous about what we think about copyright. And I'm sure you get as many opinions in here as you would if we go out on the street. So I offer up this video, and hopefully this will work. Oops, go back. Here he comes. So this is a kid who
in many ways, mine was a test. Everything was free for us. We felt free. We wanted some music, we downloaded. We wanted to print out a photo and hang it on the wall, so what? We downloaded books or e-books with a single click. We downloaded games, it all seemed like a game. But then I started writing for myself. And I came for the months, and years to create something. And the pride of having made something. How it feels to receive credit for bringing a reader as far. It's my belief that culture has to be paid for. If not with money or even praise, then with time and attention.
So there you have somebody, and this debate over copyright values is often heated and intense. How much this recent copyright trend can be attributed to cultural shifts, not something I'm trying to document, but just to raise as an issue for you to think about. So in closing, I suggest that we return to copyright basics. Looping back to where I started, the use of copyright law to regulate or censor unpopular speech is conceptually distinct from crowding out. It's not just the recent cases. As far back as 1985, of course, the Supreme Court was almost foreshadowing that this could be a debate, and you see the quotation here. The second step is to recognize that this tension, copyright as censorship, sounds in the traditional concerns of the First Amendment, and therefore, in my view, it's deserving of more judicial scrutiny and more susceptible to that. The third point is this intersection of fair use in the First Amendment is fertile ground for judicial and legislative development. Although the Supreme Court has singled out fair use as a copyright accommodation, this principle is really subject to legitimate challenge because of its imprecise nature. And finally, of course, copyright can't be everything to everybody. Under the Constitution and the copyright statutes, this regime protects expression of ideas. So no matter how noble the values of privacy, protection of reputation, etc., copyright isn't the vehicle for their vindication. For now, it's my hope that you'll take home a simple message, and that is that censorship in the guise of authorship and copyright is a trend that calls on us to stand up and take notice. It's not about freeing Mickey Mouse. It's about making sure that copyright's safety valves give full play to the First Amendment. The principles are there, the framework is in place, but what remains to be done is to fill out a robust interpretation and application. That's why we have smart law students here. That's why we have learned professors in the academy and strong advocates among lawyers. So I leave that challenge in your hands. I want to leave you with one final thought. And that is, in the world of copyright, there's no accounting for the diversions of taste and artistic appreciation. When a group of monkeys took selfies of themselves using a camera that had been left by a nature photographer, the news syndicate for the photographer claimed copyright of the photos. Now, smart as they are, it was hard for the monkeys to mount a very good defense. So, an animal rights group has now filed a copyright suit on behalf of the monkeys. My response? So much for monkey business, and on to copyright. Thanks for your time. We have a couple of minutes, maybe? Yeah, we have a couple of minutes for questions very quickly, if you do. No questions? Well, this is great. I usually get to ask the questions. This is your opportunity to ask me a question, if you have any.
I have a quick question then, just to throw one out there. How do you? I agree with a lot of what you say and the concern from the First Amendment standpoint. I've written from that standpoint in some of my articles. How would you situate the right of first publication in terms of, does it have an overlap with privacy that would be serving the purpose of copyright and therefore proper to issue an injunction as a remedy, for instance?
Well, the professor raised a good point about the right of first publication, and I think that because that is the right under the copyright, is this first publication, in effect it leaves the right in the holder's hands. So you could say in some respects you get to protect your privacy in that way, but that was a little bit of the patina, I would say, that was overlying the case of the pop singers, that particular question. So a lot of these things have been explored, some in law review articles, others in discussions, but they're just now really in larger numbers percolating through the courts.
That's it.
All right, thank you.
Sorry. Let's thank Judge McKeown for her illuminating and provocative keynote address, and also I just wanted to quickly mention that the judge will be publishing her speech in the Chicago-Kent Journal of Intellectual Property, and there'll be a symposium where a bunch of professors and potentially another member of the bench will be responding to her in the spring issue of that journal. So you have that to look forward to,
I can
too.
hardly wait.
Thank you so much.